to regulate digital platforms. This is because we've heard and we've read about the EU sanctioning Google, Facebook, Amazon for engaging into anti-competitive conduct. And these platforms also operate in Africa. And we have a number of competition agencies in the Global South, for example, South Africa, Kenya, and India, who have taken a number of measures to investigate. They have carried market inquiries. They've analyzed mergers that involve this digital platform. And what we are going to do today is to learn from the Global South. And we have on board Friso, who is also going to tell us about what can the Global South learn from the EU and the US experiences. So allow me to introduce myself for those who don't know me. My name is Vela Kigwiru, and I'm currently a PhD student finalizing a PhD at the Technical University of Munich, in particular the Hochschule für Politik. I focus on topics that focus on competition law in the Global South, which include the regionalization of competition policy and looking at how regional competition regimes interact with national institutions. And I have a special interest on digital platforms, and in particular digital labor platforms. And I would like to introduce Mr. Hardin. Mr. Hardin is the Deputy Commissioner for the Competition Commission of South Africa. And he's also an adjunct associate professor with the Graduate School of Business Leadership of the University of South Africa. And he has worked extensively in regulatory field with immense experience in competition law and policy. And he has also worked on various cases involving antitrust, for example, in communication, mining, retail, and so on. And he has attended international platforms where I had the chance to meet him, and I'm really humbled to know you, Mr. Hardin, such as the OECD, the EU Commission, BRICS, UNCTAD, and the African Competition Forum. And today he will take us through how the Competition Commission of South Africa has approached the question of regulating. I don't want to say the big tech companies, but I like the term the Competition Commission of South Africa uses, the leading tech companies, because in every market, whether it's in South Africa or India, there's always a specific leading tech companies which may not be US or EU based. And then I will also introduce Manju or Manshri. Manshri is a senior resident fellow at Vidi Center for Legal Policy. She has immense experience in competition law and policy, and she has spearheaded the adoption of the Competition Amendment Act of India in 2023, which I realize they have a provision that looks at how to identify the market power of digital platforms based on value threshold. And I'm so proud to have you here, and we are looking forward to listening from you about the EU's experience. And then allow me to introduce Friso. Friso Biston currently, he just got a job as assistant professor of competition law and policy at Tilburg University. I'm really proud of you. And he completed his PhD at KU Leuven as a fellow of the Research Foundation, and was also a Max Weber fellow at the European University Institute, which is based in Italy. Friso has extensively written on competition policy, and he recently wrote an article on understanding the Digital Markets Act. Honestly, I had a problem understanding the DMA from reading all the provisions, the preamble, to all the sections. But if you read Friso's article on understanding the DMA, you'll have a very clear understanding of what the DMA is all about. And I'm encouraging all of you to download that article. And he has published in many papers on this specific topic. And therefore, I'm looking forward to hearing from Friso what the EU and the US can learn from the Global South, and what the Global South can also learn from the EU. So we are going to start with Friso. This is a very complicated topic, and Friso will give us an introductory remark about what we need to know about the regulation of the digital markets. Then Hardin will follow Friso, and he will take us through the approaches the Competition Commission of South Africa has adopted in regulating the digital markets. And then Manju will also have time to also take us through the India experience. Thank you. Speakers, take the floor.
Okay, let me just share my screen. Great. So I hope everyone can see my slides. Well, first of all, thank you very much, Vela, for the invitation. It's really an honor to be here to share this panel with the great speakers collected. So I'm an expert on EU competition law, so that's where my perspective will come from, and I'll try to draw some lessons from that. But I'm also here to learn from everyone about the experience in the global south, where I'm less familiar with, but that I think holds great opportunity for conversation and collaboration. So with that, as Vela announced, a little bit of setting the scene. What are the digital competition issues that we're sort of concerned about on an often global level? In 10 minutes or so. This might be too basic for some people, but just to make sure we're all on the same level and have a basis to build upon together. The basic issue we're starting from is, as you know, that a lot of digital markets are dominated by one or two companies, often companies that belong to the so-called GAFAM, so Google, Apple, Facebook, Amazon, and Microsoft. I've noted some examples here in search engines. We have a global monopoly with Google, who holds more than 90% of the market everywhere except for China. In social network, we have, of course, the companies under Meta, which is Facebook, Instagram, WhatsApp. We see a bit more competition here with new services like TikTok. This market is a bit more dynamic, but still about 60% probably of personal social networking is dominated by Meta. Online advertising is actually tied to Google search monopoly and Meta social networking because it's the derived service. So there we have a duopoly of these two firms. They target advertisements based on the data they collect from your searches and then your social networking activity. Online marketplaces for transactions like Amazon are large. In mobile operating systems, again, we have two firms, with Google having their Android operating system and Apple their iOS ecosystem. This is especially important as some people skip the desktop stage and go straight to mobile. So these mobile ecosystems hold a lot of power of how people engage, interact with the internet. And then we have on desktop, of course, the old Windows operating system of Microsoft, which is still very strong. Now, why do we end up with one or two companies in each of these markets? Well, this has to do with the way these companies are set up, the way they operate, namely in multi-sided markets. So they're called multi-sided platforms because they basically tend to serve two customer groups. There's two sides to their market. On the one side, the consumers, customers like you and me. On the other side, businesses, suppliers of goods or services who like to reach those consumers. So they're essentially intermediaries. They're the gateway for commerce and social interaction between businesses and consumers. As such, they're subject to network effects, and those can be direct, as in the case of Facebook. More users joining a certain social platform will mean that even more users will join because the value of the platform is essentially determined by the number of users. You want to be where other people are, essentially. If you're on a social network where nobody of your friends is, that's not very interesting. There's also indirect network effects, and here, the idea is that you want to be where users on the other side of the platform are. So if we take a platform like Amazon, you have sellers on one side and buyers on the other. Well, the buyers will want to be where most of the sellers are. And of course, sellers will want to be where most of the buyers are to have a larger public. And so this sort of leads to a positive feedback loop. More users brings in more users to the platform, which brings in yet more users on the other side. And there's some other factors at play here. There's great returns to scale because it takes a lot of fixed costs to set up a platform like Google Search. But once it is set up, you can provide these services at a very low cost. So the returns to scale are large. There's also the learning effects from data. Think of a company like Google, which with every search trains its algorithms. If they serve you 10 results and you click on number 7, they know, oh, okay, it seems that number 7 was a better result. Let's push that one to the top for the next search. So as you have more users, your product also becomes better, which reinforces this concentration. That's why we end up with these winner-take-all markets. Now, in themselves, that's okay. Under most competition systems, a monopoly as such is not a problem. It's only the abuse. But of course, once there is market power, there is a risk of that abuse. And there's a specific risk that we go from gateways that facilitate commerce and social interaction to gatekeepers that actually halt that commerce to their own benefit. Specifically, we're concerned here about ecosystems, and this is a bit of a broader term than platforms. They use that once these platforms become big, they start building services around their core platform so that they have an interconnected web, which reinforces their market power. And I think a good example here is Apple, for example. The heart of their ecosystem is really the iPhone with the iOS operating system and their app store. But they have a lot of other products and services like the iMacs and iPads, etc. They have a lot of accessories that people use with iPhones. They have services from financial services to cloud services, and also more entertainment apps, music, news, messaging, etc. Now, this is a strong ecosystem indeed. Apple is the most valuable company in the world at this moment in terms of market capitalization. But of course, app developers use that ecosystem to bring their apps, their products to consumers. Now, if you're, say, a Spotify, that proposition becomes a bit difficult because you need to rely on Apple to get to consumers. You put your Spotify app in the App Store, but at the same time, you're competing with a different part of Apple's ecosystem, namely Apple Music, another music streaming service. And so Apple has a lot of intricate ways to actually tilt the playing field in its favor, to favor its own services, what we call self-preferencing. It preferences Apple Music over competing Spotify. And it does so through its App Store by charging high fees, for example, on purchases of Spotify or subscriptions, by ranking, putting Spotify down the list of results and Apple Music on top. It could even kick it out of the App Store if it wanted to, because it has that power. It can also use the other elements of its ecosystem, make sure that Spotify doesn't work with the Apple Watch, for example, or with the Apple speaker, or that you can't use Spotify with your voice assistant. In short, ecosystems have a lot of ways in which they can use their own power to their advantage, rather than being sort of a more neutral conduit for the commerce of others. And this leads to a lot of investigations, especially the EU has been leading the charge here. But those investigations come with their difficulties. Typically, they start, of course, if we're talking about abuse of dominance, with market definition. Which market are these part of? But that's complicated by the platform business model. Do you define one platform market, and do they only compete with other platforms? Or do you find a market for every side, a consumer side and a developer side, for example? Talking about market power, well, I've given some of the factors there. There's always a counter argument saying, look, these digital platforms, they operate in dynamic markets. Innovation can mean that, a monopoly one day is crushed the next day, this creative destruction, in the words of Schumpeter. And then I think the most important part is determining whether conduct is actually abusive, anti-competitive, and thus in the EU and US, which tends to mean, does it harm consumer welfare? Sometimes that's hard to say. Of course, the way to ascertain whether that is the case is through legal tests of specific forms of abuse, because self-preferencing is a very useful term to understand what happens in digital ecosystems, but generally reference is made to more specific forms of abuse. So do we see tying conduct? This is a classic in digital markets. We already know it of 20 years ago when we had the first Microsoft cases. Now we're seeing it again in Google Android, for example. Exclusivity arrangements. For example, Google pays smartphone makers to take their services, in particular Google Search, Google Chrome as well, so that they're the exclusive supplier on those phones. Discrimination is actually a classic form of self-preferencing that we saw in Google Shopping. Google putting its own services on the top, and the other services, for example, on page 4, nobody will find them. So you're discriminating against competing services in your ecosystem. The use of data is also contentious because if you're a platform, you can see what happens on the platform. You have access to a lot of data. For example, if you're Amazon, you see which kind of products your sellers are producing, what they're selling, how much, at which times, at which prices, and you might be inspired by them. You could say, oh, that's a bestseller. I'll go make the same product. We had a case on this in the EU as well, and a suit currently ongoing in the US. Excessive prices. Now, this is a bit difficult because competition regulators tend to be a bit cautious when intervening in prices because the market tends to be the best way to set prices. But still, some of these prices of platforms are very high. For example, Apple with its App Store charges a 30% fee on everything that happens in the App Store, which developers certainly have been complaining about. There is also predatory pricing. This is actually the opposite. It means charging excessively low prices so that your competitors can't keep up and might be pushed out of the market, of course, with the long-term idea of then increasing prices again once you're the monopolist. And a final one I'll mention here is price parity clauses. This we know from hotel booking websites such as booking.com. And what they entail is that the platform tells their suppliers, in this case hotels, that they cannot charge a lower price elsewhere. They have to charge their best price on the platform. But while this might seem pro-competitive, actually it means that the price level becomes uniform. Nobody has any incentive to lower their prices anymore, and it's bad for both consumers and competing platforms. So this was a sort of rush through the many types of anti-competitive conduct, and we can certainly come back to some of them if that's interesting. I'm given here a short overview of the cases we've seen in the EU. This has been quite some. In the US, we've mostly seen so far cases being brought, but no decisions yet. One exception is, for example, the case that Epic Games brought against Apple for a similar issue as Spotify, but that has mostly failed because US courts tend to be, US doctrine has become very restrictive, and a lot of claims that you can make in the EU are impossible in the US, for example, when it comes to refusals to supply. I'll end with some of the difficulties we've been dealing, because even though there's been a lot of cases and generally these have been successful, there's a lot to be remarked on. These cases were complex because of the complex business models they relate to, but then again, competition law is a flexible branch of law with flexible provisions. So there was never a problem in finding abuse. It's only how long it took to find that abuse, essentially. A lot of these cases took 3-4 years, up to 7 years in the case of Google Shopping. And there's a problem there that once Google uses its dominance to, for example, monopolize this other market for comparison shopping or other flight services, for example, once that happens, it's almost impossible to reverse it because market power in digital markets is very sticky. It tends to stay there because of these network effects and other factors I've talked about before. So there's an incentive here. There's for early intervention before that happens, and to really think well about the remedies imposed at the end of an investigation. Because the remedies that we have seen, for example, in Google Shopping or before that in Microsoft, have been mixed at best, and often they haven't had a lot of effects at all. So I think I'm coming to the end of 10 minutes, Shirley here, so I'll stop, pass the floor on to other experts, and then I'll happily say something more at the end.
sorry for that. Thank you so much, Preso, for giving us these introductory remarks, because most of us use these platforms and we don't understand some of the anti-competitive conduct that these platforms engage in and how they affect the consumer and the business user. So I would like Hardin to share with us his presentation about the approach that the South Africa has undertaken so far.
Thank you. Thank you, Vela, for this invitation and arranging this this session. And of course, it's a pleasure to share this platform with the experts. I would not call myself an expert specifically, but to the extent I say something, about maybe ongoing matters and before the competition authorities in South Africa, those would be my views and not the views of the Competition Commission of South Africa, which I serve. I'm also at least fortunate that I can also be adjunct associate professor when it suits me. So thank you very much. I will give my remarks. I did not prepare slides, Vela, because I was, I think I got a sense that you want an interactive session on these, but I think Friso's slides were quite useful because it does situate the issues quite well. From South Africa, and I will start really where we started in 2020. So we had been engaging a lot at UNCTAD, OECD, on all of these challenges that the digital platforms were presenting in a way. And this is something that a lot of countries, as Friso has stated, had been pursuing. We then in 2020 published a digital strategy, which is competition in the digital economy. So this is available on our website. And the focus of that paper was on us looking at those interventions that could open up opportunities for local digital firms and to identify priority areas for enforcement, market inquiries, or advocacy. And in pursuit of these goals, we focused on key areas, which is firstly to understand the markets, because I think there had been a lot of discussions around this, so we needed to locate those within the context of our economy in South Africa. We looked at potential for market abuse by large digital platforms, especially as these are characterized by network effects. Potential for killer acquisitions that remove maverick firms. Potential for collusion in digital markets through algorithms. Consumer protection on use of personal data. And finally, digital markets and their impact broadly on the architecture of the economy. So we needed to explore how would these affect the industrial structure of our economy. And we do note that various countries, so if we look at other jurisdictions, what has been happening is that some jurisdictions have pursued ex ante approach by prescribing laws, but also hybrid in nature because that has tended to be accompanied by some level of enforcement. And we have seen that with these markets, I think it could be helpful to be open to both approaches. It could be, ex ante measures as well as ex post issues to deal with specific firm conduct. And what have we been doing currently in South Africa is we referred in March 2022 a case against Meta. So this is a case that is being prosecuted before the tribunal, and this was against a local, I would just call it a local platform firm called GovChat. So what this company was doing was it uses the WhatsApp account to aggregate messages and allow consumers or users to access information. It could be, government information about key messages, and I think they were quite active during COVID. And I think reaching probably users of about 600,000 in some cases per day. And what panned out is WhatsApp then alleged that they were violating the terms and condition of WhatsApp's API, or even the use of the actual number. And what we now have is that this case is before the tribunal. The tribunal had also granted an interim order in favor of this company as we were investigating the case. We launched a market inquiry into online intermediation platforms. So looking at app stores, impact of Google search, some local classifieds and so forth, as well as the Uber Eats and all of these other delivery platforms. So in this inquiry, we published a provisional report, and the commission is yet to release its final report on this matter. So I'm a little bit constrained on this particular one, Vela. We also have launched another inquiry again into these markets. So this was done in March this year. It's a market inquiry into the distribution of media content on digital platforms. So this is the media and digital platforms market inquiry. This is a similar inquiry to what you have had in Australia through the ACCC, looking at mostly the sort of the bargaining position between the platforms and the media houses, as it were. So this is a new inquiry that the commission will be embarking upon. And I would probably conclude by looking at what has been happening also on the continent broadly, because there are quite significant developments in countries such as Kenya. But you would know also that the heads of competition authorities in Africa have started an initiative where they will be meeting to continuously assess digital markets and identify areas of focus. So it could be a joint enforcement action, it could be joint market studies as well. So we're going to see, there will be a lot of engagements on this later this year at the African Competition Forum biennial conference in the Gambia. There's also a very significant development with respect to the African Continental Free Trade Area. We do have a draft protocol to the AFCFTA on competition policy. So this is a protocol that was considered earlier this year by the heads of states, and it is being considered, and it could well be finalized before the end of the year. In it, there is Article 11, which talks about abuse of economic dependence and any other anti-competitive practices. And that particular provision looked at the conduct of so-called gatekeepers or core platform firms. So this is likely to see some coordinated action, from a continental perspective, depending on how quickly the protocol gets implemented. In it, there is also provisions to pass regulations. So I think gatekeepers would be designated as it is in the EU.
No, we haven't worked in the banking industry.
Okay, so that's fine. At least it's not from you, Vela. I thought maybe you were saying I was running out of time. No, it's fine. So there's that approach that gatekeepers would have to be designated or core platforms at the continental level, but that would be made possible, of course, through a regulation that the Council of Ministers will publish at a point to be determined. But these are the things that when we look at the continent, we are likely, as just to summarize, we are likely to see, as we are seeing now, some interventions at national authorities. And I think there is some action in South Africa and Kenya that we can talk about. We are likely to see a coordinated approach by the leading competition authorities. And they have already met twice, last year and this year, and we should be seeing some results soon. And of course, the AFCFTA, depending on how quickly the protocol is implemented and ratified by the state parties, that would then provide another opportunity for competition authorities on the continent to look into these issues at a continental level, more like what we are seeing in the EU. So I will pause here, Vela. This is the sort of the broad overview I thought I would share. Thank you.
Yeah, thank you so much, Hadin, for those insights. I have a number of questions for you. But in order to make this more engaging and to enhance clarification of questions, if you have any question of clarification you want to find from the South African perspective, feel free to ask. And Hadid, I have like 2 or 3 questions. And the first one is, if you could mention to us the challenges the Commission has faced in regulating digital markets, especially in assessing digital mergers, the key challenges, so that other competition agencies in the Global South that have not been able to assess such kind of mergers can learn from. And then another question I'd like to find out is regarding the preliminary findings of the online intermediation platform. What were some of the constraints you found that hinder the entry, the expansion, and the participation of South African-based digital platforms in the digital market ecosystem? And finally, what will be the most appropriate remedial approach that competition agencies in the Global South could adopt when dealing with some of these cases? Thank you.
Thank you, Vela. On the on the challenges, I think this is a question that has been, quite, difficult for us, because when the focus on digital markets started, this was really a focus broadly of the EU, but there were some national authorities, Germany, France, that were taking some action. And we looked at this and resolved that perhaps before we sort of take any step, we should attempt to understand the specific challenges that firms faced within our economy. I think there are global issues that were coming up, but we needed to understand the actual impact. And I think once we do that, we are able to think of perhaps an appropriate response to this. And in this particular case, our first priority was then to embark on a market inquiry, focusing on intermediation, online intermediation. So we do have, local platforms. There are these other global platforms, but we saw a big opportunity there for participation by small businesses or even established businesses. So the key thing has been to try identify areas that would have an impact in our economy. And with respect to this inquiry, I think I would not be able to, talk at length about it, because the provisional report was issued last year. It is out there. I think it details what were the preliminary findings and suggested actions by the panel that we have tasked to conduct this inquiry. But I think, we are probably closer to finalization of these, and it would be maybe useful to talk about it once it has been concluded, because I think there has been a lot of engagement, with the panel that we have appointed. But what I would say is that for, as you say, the Global South, what is it that we should be doing is really to identify those specific challenges that would affect, our economy the greatest. But I do recognize that it would, in some cases, be difficult for national jurisdictions to do so alone, which means there is a need to engage at a regional level. I think we are fortunate that we have, quite strong regional economic communities. So you could have an engagement at that level, an engagement, as I say, but this is medium to long term, at a continental level, but also as we do in the African Competition Forum. So I do see that to overcome some of these challenges, we need to really enhance our coordination and try as much as possible to identify those priorities that would have the greatest impact in our domestic economies.
Okay, thank you so much. So we have a question from Odi, and she asks, do you believe that the South African small merger guidelines sufficiently addresses the obligation on firms to file smaller digital mergers, given that law firms advise their clients not to comply with the guidelines unless mergers have been carefully scrutinized? Has the competition considered publishing regulations as opposed to guidelines containing the small merger threshold?
All right, no, thank you very much for that, and thanks, Odi, for the question. What we have found in South Africa is that there is, quite acceptance, and firms are quite receptive to guidance from the authorities. So the guidelines we've issued, for small, major, guidelines to deal with, these potential killer acquisitions or any other guidelines. I think we have seen some good reception to this. The challenge, of course, is are these transactions prevalent in our economy? So do we see a lot of startups being taken up by the larger firms? This is something that we have attempted to provide guidance to, that it does matter. I think we've guided firms that they should look at transaction value, as everybody has been doing. So the transaction may not meet the thresholds based on turnover or asset value at a point in time. But if, for instance, the transaction value is higher, of that firm, and it even meets the thresholds for notification, we have advised firms to notify the authority, of those transactions. And it is, there's no really need for a regulation. The law empowers the competition authority or commission to call for notification of any transaction, any major transaction that falls below the threshold. That just has to happen within a 6 months period. And the guidance is there to assist, but I think the law empowers the competition commission sufficiently to act where it has to. Thank you.
Thank you so much for that detailed explanation. So there's another question from Lottie asking, where a company offering a digital platform for business operates in your jurisdiction without physical presence, but they engage in anti-competitive conduct against local competitors, e.g. online ride-hailing sector, how would you investigate such a case? So I think this question is bordering on the question of jurisdiction.
Yes.
Yeah.
No, thank you very much, Lottie, for that. Interestingly, this question is not new. We have faced it on many cases with an international dimension that we've looked at. The key one, which you can have a look, is a very interesting ruling by the Competition Appeal Court in South Africa on the banking case, the Forex case, which deals with this issue of jurisdiction. We had thought maybe the act is clear enough because it says, well, conduct that has an economic effect, such as some effect in the economy is attracted by this. So we thought that was wide enough, but I think the courts have expressly clarified this, that our jurisdiction is wide enough. So if we are dealing with companies that do not have sort of an office or anything like that in South Africa, but they generate revenues from our economy, I think the law will apply. But the challenges of prosecuting such firm would arise as they do in any other jurisdiction where the particular firm has no office or any, some assets that we can attach in the event that there is some action. But it is quite clear that the Competition Act has been crafted in a way that we are able to intervene in those situations.
Okay, so that we can hear from Manju, maybe you can answer the last question from Professor Daskaleva, who is asking, I should like to understand how Article 11 of the FCFTA Competition Protocol defines economic dependence.
Oh, yes. I would refer him to the draft, but I would do my best because I don't have the protocol just before me, but it is a because it starts broadly with economic dependence as we know it. I think it's similar provisions you would find, I think, in the laws, Italy, a lot of Francophone countries, and I think Morocco, or Algeria in particular in Africa, we do have already authorities with those provisions. So the definition, without really trying to paraphrase what is in that protocol, I can say to you, it's along the same lines of the definitions of economic dependence that exist. But what I can do, maybe I can post him the definition now as I pause, so that I just want to make sure that what I say it's what's in there.
Okay, thank you so much, Hardin, and thank you so much for the explanation and clarification. The South African experience is very important, particularly for developing countries. And now we move to Manju. She will take us through the Indian experience in regulating digital markets. Thank you so much. Welcome.
All right. Thanks, Vala, first of all, for having me here. This has been great. I mean, I've learned so much listening to the South African experience and also to FreeSource. So I just hope that whatever is happening in India with the Competition Commission of India sheds some light in terms of where we are going ahead. What's happening in India is actually quite interesting, because we have just about revamped our Competition Act. There was a competition amendment bill that was passed as recently as April 2023. But interestingly, it's not this act that targets digital markets, because this particular bill was stuck in the parliament for about 4 years. It took that much time for it to come to light, but this is not the bill that addresses digital markets. And perhaps the fact that it took 4 years for us to pass an amendment bill should give you an idea in terms of what are the pain points that one can expect when they're trying to legislate in India, particularly competition legislation in India. So that's one part of it. So the Competition Commission of India has a sum total of about 15 years of experience. Although our Competition Commission was established well in 2002, it was only much later that it began functioning, owing to a bunch of writ challenges at the Supreme Court at that point in time. So the Commission, in comparison to a lot of its counterparts, has had a smaller history of enforcement, which means questions like delineation of relevant market or ensuring that investigations move through quickly are also problems that affect the Competition Commission of India. And perhaps a little more starkly, given that the Competition Commission of India routinely faces problems with hiring and staffing. Now, I say this particularly because a law without the necessary capacity to enforce it is as good as not having a law. And my fear with deliberations on a digital competition law right now is that although in spirit that may be a great law on paper, the enforcement efficacy of that is also going to be inextricably linked to capacity building. That's definitely one problem that we're facing in India. Second, let's talk a little about what digital markets mean for a country like India. And whenever we talk about India or any global South country for that matter, and perhaps something that specifically distinguishes India in this regard is just the humongous population that we have. Currently, we have close to 680 million internet users, and that is more than the population of so many countries. So when you look at what are the motivations that that any leading technological companies have in India, population and therefore the kind of data that can be generated in a population like India will become very important considerations. And these are also political considerations that will shape how we are looking at our data governance policy or our digital data protection bill or the Digital India Act for that matter, or more recently what the Ministry of Corporate Affairs is sort of doing with the Committee on Digital Competition Law, where after the 53rd report by the Parliament, by the Finance Committee of the Parliament, the committee is trying to examine if a digital competition law is required for India, specifically one that moves in the favor of ex-ante regulation. Now, for a country like India, apart from the very obvious benefits of, ex-ante regulation, there is one important benefit that I see coming through. One, especially when there is a capacity strain with the Competition Commission of India, doing a case-by-case analysis of every problem that comes up before the commission is extremely resource intensive. I mean, we have seen this in Frizo's presentation as well, and in terms of what Hardin was also sort of talking about, the time taken for these investigations to unearth, economic evidence at the DG stage, etc. All this is a lot more complicated when you cut the capacity by 1/10. Cut the capacity by 9/10. And if you have the commission running in a very lean fashion, then ensuring that it is administratively efficient becomes important for reasons that are not just to do with digital markets. Now, that's one of the stronger reasons as to why India is seeing a push towards ex-ante regulation. And the second reason, of course, is the fact that India also has its own homegrown digital economy that is flourishing at an increasingly high rate. So we want to ensure that the various points of contact for a lot of these startups in the digital ecosystem are as hassle-free as possible when it comes to their interactions with big tech companies. What do we mean by this? We want to ensure that smaller businesses and big tech and larger leading companies, go forward and collaborate, but the terms of those collaboration and what that collaboration means must be something that does not take care of an unfair bargaining position that these business users have. And this has been a very important reason for why India is looking to go the ex-ante route. I mean, yes, there are problems with big tech companies having, network effects, that winner takes most in a lot of these markets. And also, we do have concentration when it comes to, our e-commerce market or our search engine markets. But I think the two fundamental motivations that is driving India currently is that the way we are going about with ex post, assessment of digital markets, at least in India, is time-taking and resource-intensive. And second, the fact that none of our existing legislations or regulations, for that matter, look at the asymmetry in bargaining power between business users and platforms. And our startup economy is a significant portion of our industrial, the industrial component of our GDP. And we want to ensure that the digital ecosystem remains open, free, fair, and inclusive, and which is why we're hopefully moving towards an ex-ante regulation. But again, what that regulation would look like for a country like India is something that the Ministry of Corporate Affairs is currently debating, and I'm thankful to be a party to that sort of a deliberation. And what I largely see that the government is concerned with, or the members of the CDCL, the Committee on Digital Competition Law, is concerned with, is ensuring that there is a level bargaining and a playing field, no matter what the size of the enterprise is. That's in terms of what is happening in India in the policy ecosystem. Let's look a little bit in terms of what's happening with our cases. Two cases that have seemingly made headlines with the Competition Commission's investigations have been the two recent Google orders, one for a 900 crore penalty and the other one for a 1,300 crore penalty. Now, again, whenever someone asks me about what is striking about the Google investigations, I mean, it's a little too obvious for me to not notice that there are two Google orders that come out right after one another. And this means that a market inquiry into one substantially helps out with a market inquiry of the same entity in a related market. And the rate at which the CCI has disposed these two Google cases is astronomical. We've not seen that sort of an investigation, that two massive investigations, sort of take place at massive orders come out at such short intervals. So this is strongly indicating that one, when we're talking about any leading technological giants, their market powers cannot be sourced down to one relevant market. So something that I'm really interested to see is how going forward, the CDCL will take a call on whether we should define a relevant market to begin with, or should we go without defining a relevant market, just on quantitative and qualitative thresholds, for ex-ante regulation. Because that's something I've noticed even in the document that you shared with me, Vela, the one on the one that Hardin was also sort of referring to, because although there is a definition of gatekeepers, and though there is the term core platform service used multiple times, I did not come across a definition of what a core platform service is. And that's perhaps for the better, because that means that we are essentially saying that we can recognize gatekeepers or gatekeeper-like entities in markets that are not in core platform services that are not already defined within the Act. And this might just mean greater flexibility for a country like India. Again, coming back to the Google CCI investigations, it definitely shows us that investigations in one market significantly help in resource crunches in other allied markets. And the second thing is, that becomes very obvious to me, is that the penalties under the Indian Competition Act must be, are largely to ensure that there is a deterrence effect, and the penalty is somehow always supposed to, at least in some way or form, in spirit, at least quantify the kind of harms to the market that, would have occurred. But the problem that I see with the Indian Competition Act specifically is that there has not been a single case decided on private enforcement, which means any market participant that remains, that has been harmed in the course of an anti-competitive conduct does not get reparations for such a conduct by, say, a big tech or a large digital intermediary. Now, this is problematic because if you allow large digital intermediaries to continue without an ex-ante regulation, they will end up causing as much harm as possible to smaller businesses, but businesses will not have a chance to claim that through reparations, because India's private antitrust enforcement mechanism is simply that nascent, or something that hasn't kicked off entirely. Although it allows for a private enforcement remotely under the Competition Act, it requires private enforcement to only kick in after a final appeal at the Supreme Court stage is disposed. And God knows how difficult that is to, sort of get a Supreme Court order on something like this very quickly. So these are some of the considerations and peculiarities that, I thought I should bring into our discussion today, because this really sets the Indian context a little differently from how we're seeing tech regulation emerge in other jurisdictions. The last point that I'd like to sort of talk about is India's experiments with digital public infrastructures. And for those that may not be very familiar with what this means, we are trying to build many digital infrastructures that can mimic physical infrastructures, for instance. And one important experiment that India has embarked in this regard is the ONDC, or the Open Network for Digital Commerce. Now, what this tries to do is it tries to set up a network as opposed to a platform where sellers and buyers may connect on different sides of the network, and the network mediates an e-commerce transaction. And this, hopefully going forward, will reduce India's reliance, or the small sellers' reliance, only on a handful of intermediaries, because Indian e-commerce is currently an oligopoly. I mean, it's almost equally split neck to neck between Amazon and Flipkart when you look at e-commerce retail. And hopefully something like the ONDC is going to help us ease these sort of concentrations and bottlenecks in critically important markets, or markets that are critically important to the Indian economy. So these are just some tidbits on what's happening in India, and I'm very, very happy to take questions. And again, thank you so much for your remarks, Friso and Hardin, and thank you so much for inviting me here, Vella. It's been a pleasure listening to you all.
Okay, thank you so much, Manju, for your presentation. You have identified important issues of consideration that the other experts had not mentioned. For instance, the question of having alternative gatekeepers, what India is doing, and also the question of private enforcement in order to provide redress mechanism for those who suffer from the anti-competitive conduct that the gatekeepers are engaging in. And I also bring to attention what had been brought to attention, the need to protect a country-based digital platform to ensure that they can enter and expand and participate in the market. I'm sorry, I have a lot of people coming in. We had a problem with our Zoom link that indicated that the session will start now. So I'm trying to also admit them. I wanted you to talk about the Standing Committee on Finance recommendation, report on anti-competitive practices by big tech companies. If you could just give us a summary of what the recommendations were and how these recommendations are going to influence the next legislative initiative that India might take.
Absolutely. Well, I think the 53rd report, the Parliamentary Standing Finance Committee's report on big tech regulation in India, sort of clearly sets the context for what would a digital market regulatory regime in India, or what should a regime of that sort look like when it is tailor made for the Indian subcontinent. So let me just give you a brief bits in terms of what is it that led up to the Finance Committee report, and what is it that the Finance Committee report sort of recommends, and what is it that the Government of India plans to do to sort of take these recommendations ahead. So firstly, as I was sort of talking about in my opening remarks, the Competition Commission of India has seen a lot of cases that has come up before it with relation to anti-competitive practices, particularly relating to large digital platforms. When it came to enforcing the ex post mechanisms that are available under Section 3 and Section 4 of the Competition Act, the Commission also faced a few setbacks. As we've sort of seen earlier, the delineating relevant market became a very troublesome issue. So in fact, in some of the earlier cases where, when Snapdeal was involved, Snapdeal versus the Commission of India, in this case, the Commission looked at e-commerce to be completely a different relevant market from, say, brick and mortar stores. But later on, when there was another Amazon case that came up before the commission, and one involving Ashish Ahuja versus the Competition Commission of India. This was an informant that had gone to the Competition Commission of India on suo motu reference. We saw that the commission sort of defined the relevant market, the e-commerce relevant market, to mean that both brick and mortar market and the e-commerce retail market are in fact part of the larger Indian retail market. Now, this was a significant sort of difference in terms of how you're looking at relevant markets, because, as we all know here, the relevant market is perhaps the most important step when it comes to truly catching or truly being able to gauge the power of a platform. And the biggest challenge, I believe, that digital markets have posed to us is how do you really account for intangible things that we haven't accounted for in the past, such as network effects or access to data, or the fact that access in one market or a dominance or a gatekeeper position in one market means superior bargaining powers in related markets. Now, just these are some of the kind of things that I don't think the Competition Commission of India, like most other competition regulators, were at that point in time ready to sort of take on these challenges. And this led to a situation where, despite repeated cases against many large digital intermediaries, the cases were not being admitted by the Competition Commission of India, because in the relevant market that they delineated, they found this entity to not be dominant. And without there being proof of dominance, the Competition Commission of India couldn't proceed with any investigation. Now, noting this and noting the sheer volume of cases that the CCI sort of started seeing, it was clear at that point in time that we are trying to remedy a problem to which the answer does not already exist within our competition law. So there's perhaps a need to relook at what fair competition means in digital markets. And after a series of efforts by other parliamentary standing committees, so there was a committee on e-commerce that also recommended similar, that also made similar observations on the nature of concentration in the e-marketplaces, in Indian e-marketplaces. And this was shortly followed by the Parliamentary Standing Committee in December 2022, which released its final recommendations and identified 10 anti-competitive practices that it thinks gatekeeper-like entities, simply because of their sheer market power. I mean, it's funny to keep saying market power, when I don't know what relevant market I'm talking about. But again, let's call it market power for a lack of, a better term for that. But the sheer amount of market power that these, intermediaries continue to hold, or the fact that these market powers even give them access to adjacent markets and quickly establish their dominance there. They saw that this is something that our current Competition Act cannot perhaps remedy, and therefore suggested that there is a new Digital Competition Act that is passed that regulates gatekeeper-like entities. And the term that the parliamentary report uses for such gatekeeper entities is significantly important digital intermediaries, or CIDs for short. So the parliamentary committee recommends that the Ministry of Corporate Affairs, which is the nodal ministry for competition law, targetedly identify such cities and make a law that is particularly applicable to them in their dealings both with customers and other businesses. So currently, the CDCL, that is the Committee on Digital Competition Law, has been formed basis this report. And this committee is deliberating on what the future of a digital competition law for India is going to look like. I'm fortunate to be on this committee and assisting the Ministry of Corporate Affairs, in its dealings. But I'm very, very excited to see what the outcomes of this negotiation will be. So that's insofar as the Parliamentary Standing Committee goes.
Okay, thank you so much. I hope you've learned new things. I have very limited knowledge on the Indian experience, but I know some of the cases against Google, against Oyo in the travel and accommodation sector. So I'll open the floor so that if you have any clarification questions would like to ask Manju, you do so. But there is a specific question in the group. Let me see. And the question is that to Hardin and Manju, that do you see acceptability among competition authorities in developing countries to appoint technical digital experts at the competition regulators to help with the formulation of the risks and remedies? We saw in the EU that the leading digital companies easily sidestepped some remedies by the tweaking of the technology leading to the technical compliance with the remedies, but also their continued abuse dominance. So we'll start to answer that question before we move to Friso, between Hardin and Manju.
May I start, Hardin, if that's okay with you? Yeah. So yes, I mean, this goes back to what I sort of started with, in that this is exactly the sort of a compliance issue, or the requirement for extra capacity that would come up when we are trying to sort of update our current laws for digital markets. And while I'm not sure how receptive India would be to appoint technical experts, I really hope that it is an important point for discussion. And if there is a decision made to not to appoint such experts, it is made on solid grounds. Because currently what I've noticed, even with the Competition Commission of India, is that they have created a digital markets unit-like entity, but it is largely an advisory group. But for the kinds of compliances I believe that the question is trying to point me towards, we would require engineers, policymakers, and lawyers to have dedicated teams that ensure that compliance with the obligations that are put out by such acts are done both in spirit and in substance. And I suppose at this point in time, my hopes and your hopes are as good as it gets in terms of hoping that India appoints a set of technical experts that can watch over such compliance mechanisms to be fruitful.
Okay, thank you. Hardin, do you have something?
No, thank you, Vela, and thank you, Majinshri, for that, because maybe this is this is the first question we faced, by the way, as authorities, when we wanted to look into digital markets, whether do we have capacity, because most of authorities are sort of composed of lawyers and economists. And there was a response very early on that the lawyers and economists who have been doing these antitrust cases for years did not have sector-specific experience, because so that was the first response. But it does seem to us also that with these high-tech markets, digital markets, understanding algorithm, analyzing big data to understand consumer behavior, this is something that requires specific expertise. And I can say to you that I know at the very least from the BRICS community, we have an initiative, and I think Brazil has been leading on this, just to understand, and I think they've already started building some capacity internally to look at the kinds of capacity we need to respond to this. And I think this was also not just digital markets, but also issues around big data. How do we start using big data or to even understand other practices? So it can be, bid rigging in cartels. How do you aggregate information to start seeing some patterns? So it looks to me, this is the expertise that we require, and it's expertise that would be required even during, an investigation. And it's correct, I suppose, when you monitor commitments, it also becomes quite important. At least from our experience, competition authorities, are quite open to this. The question has been prioritization and budgets, because already as they are under-resourced authorities as we speak in developing economies. So where do we, because there are certain things that we need to do first. Would this be at the top of, an authority, in developing economy, kind of, would it be top priority that you start building this capacity when you still have other challenges that you are facing? That's why we think the best way would also be to strengthen coordination amongst competition authorities so that we start sharing expertise. We engage, for instance, with the EU, on these issues. The UK, already they're building that capacity, and we can learn from that. But I think the long and short of it is that competition authorities are quite open. I think it seems, the sense is that we should understand these markets. We should be able to take decisions that are informed at the end of the day. So I hope that that answers your question. Thank you.
Yeah, thank you so much. Initially, when I was organizing this event, I thought 2 hours will be so much, and I see time is really moving. But just one question for you, Manju. I'd like you to bring to the attention of audience some of the anti-competitive issues the Competition Commission of India found in the case of MMT and oil regarding the question of parity clauses. And then we move to Fraser.
All right. Thank you. Well, I'm happy to sort of speak about this because I think the MMT OYO is actually one of my favorite cases, not in terms of only what happened at the commission, because it was a saga of a few, cases that were filed before and after on the MMT also, against MMT as well. And the details are amazing of the, OYO and Make My Trip case. So OYO, Make My Trip is a travel hotel aggregator in India. So you can go on Make My Trip, make flight bookings, you can make, you can make any sort of hotel bookings, you can make cab bookings. So it's basically some sort of a travel partner that's first meant for domestic purposes, but it's also started expanding internationally now. OYO, on the other hand, is a budget chain hotel. So OYO's business model has been to identify old buildings that could pass off as hotels potentially, renovate them a little bit and sort of have a bunch of basic requirements that, you sort of put together and then have OYO and sell them out under the brand of Oyo. So you would know, for instance, if you ever went into a city and wanted to get an Oyo room, that meant you're signing up to getting getting a room that will meet certain very basic minimal criteria. That's enough for you to perhaps spend a day or two, especially if you're traveling to work. You have Wi-Fi, you have clean water, you have breakfast, the bare minimum, but it's not a place that you would go for, say, a holiday or something of that sort. Now, Oyo's main business model was to, in fact, buy smaller properties closer to business centers in the city so that people traveling in and out of work could conveniently use Oyos, even at short notice if they were to sort of book it, because otherwise business hotels tend to be extremely expensive. This is the kind of business model that sort of Oyo put. Now, one of the first thing with platform parity clauses that hit Oyo is that Make My Trip allegedly asked Oyo to price Oyo rooms the lowest on Make My Trip's platform, lower than what Oyo was pricing its own rooms on the Oyo app. Now, this was a problem on two grounds. One, the Oyo app saw a huge clout of customers precisely because it offered the lowest prices on Oyo rooms specifically. And Oyo catered to a very niche crowd when it came to budget hotel bookings. But Make My Trip wanted Oyo to have the least price on its own website, and this led to a platform parity issue, which is what brought this case up with the Competition Commission of India. Now, this is problematic for Oyo for reasons other than why it would be problematic for any other hotelier in India, for instance. So in India, hotels, except barring a few big chains of hotels like the Four Seasons or the Taj or these luxury hotels, most hotels in India are very specific to localized locations. They are not chains. They're not, there are no hostels or anything of that sort. These are usually hotels run by small business owners. Now, given that these owners do not have any other app where they sort of perhaps they don't have their own apps where they sort of advertise their own properties, saying yes to a platform parity clause for an exchange of more visibility on Make My Trip's platform was an okay deal for most small hotel players. But this was not the case for something like Oyo, because the reason Oyo's app was being downloaded very much on the Google App Store was because it was treated as a budget-friendly hotel app on the Android App Store. Now, the moment you take this away from Oyo risks this becoming a fundamental blow to its business model entirely. And this is what led to the case of the Competition Commission of India, which also understood this to be an anti-competitive practice. But again, with something like a competition appeal, it's always a very good and interesting question to ask any competition lawyer you would meet from India in terms of, okay, what happened after the CCI order? Because the real story never stops at the CCI. It ultimately goes down to whether there was an appeal challenged over it, and sometimes because the high courts and Supreme Court in India sometimes recognizes writ jurisdiction also in cases of appeals, the number of bottlenecks through which the recovery of such penalties are halted are numerous. So although the Competition Commission of India routinely levies a lot of penalties against those infringing the Competition Act, our recovery rate is extremely low because the judiciary's component of what happens in the appellate stages once the case leaves the CCI's hands is very, very murky. So yeah. This is Make My Trip is yet to make one final appeal with a joinder of a bunch of its cases. And when that happens and when there's a decision, I will be sure to email all of you in terms of what happens. But apart from that, this is insofar as where the case has progressed up until now.
Yeah, thank you so much. The reason I asked you to explain that case is for FreeSort to understand that there's a lot happening in the Global South. The competition authorities in the Global South are taking measures that will ensure that the digital platforms that are based in those specific countries are also able to compete in the market. And it's not all about the US or EU big tech companies. Even at the national level, we have leading tech companies that might be engaging in anti-competitive conduct. Now to you, Friso, and one of the issues I'd really like you to look at while addressing us is whether Global South countries need a separate legislation for digital markets, either at the national, regional, or continental levels. Thank you. Welcome.
Friso, I believe you're on mute.
Thanks for that. Yes, so also a couple of slides here, but it's already been so great to hear from Manju and Hardin. As you say, Vala, there's so much to learn in the other direction. I was very happy, for example, when I found out that the Competition Commission of India had a decision on horizontal shareholding by ride-hailing firms, which we haven't seen anything on basically in Europe or the US. So that was a real gem. And same at the market inquiry in South Africa, from which I've learned a lot. So great resources. I'll be, my expertise starts in the EU, so that's where I'll start from with a short look at the DMA to see, what is this ex-ante regulation in practice once in a jurisdiction where we have the full regulation that has entered into force and is to be applied, a couple of months from now. And then I'll try and sort of imagine how that could work elsewhere, if at all, because as we've heard from the other speakers, there are initiatives in that direction. Now, a short trip through the DMA then, and I'll stick to 10 minutes in total here. Of course, DMA doesn't exist in a vacuum. All over the world, essentially, countries have been proposing, suggesting, or implementing ex-ante regulation to complement competition law. There's been different approaches. I think Eleanor mentioned in the comments the approach of Germany, which stuck closer to its original competition law, relied on that heavily with new interpretations, but also complemented it with a new provision in the Competition Act. In other jurisdictions, they went for completely separate instruments, and that's what the DMA is. It's truly something else than competition law, which has been stressed repeatedly. It's, of course, an ex-ante instrument to basically tackle the limits of ex-post competition law. And I've mentioned some of those limits earlier. I think speed is really the main one that they're trying to solve for, because once you have a decision and start implementing a remedy, basically the anti-competitive market situation might have cemented itself and it becomes very difficult to reverse. So the DMA solution is to basically do away with all those things that take a lot of time: market definition, market power assessment, and the analysis of anti-competitive effects. So instead, we work with not a market power concept, but a gatekeeper concept, and no theories of harm and forms of abuse that have to be specified, but rather simple do's and don'ts. The overarching goals here are a bit nebulous or vague at times. They're fairness and contestability. So not undistorted competition, which we know from competition law. They are not really defined, but at least described in the DMA. I think the important thing the way I conceive of them is that fairness relates basically to the balance between these platforms and their business users. Is that a fair balance between the rights and obligations? While contestability is not the sort of business user platform level, but the platform versus platform level. Can startup platforms have a fair shot in this market? Can they compete on the merits to potentially, push these incumbent platforms from their position? Now, how is this implemented? Well, as I said, not a market power concept, but this concept of gatekeepers, which we find in some other legislation as well. Basically, there's a list of platforms that are core platform services. These are 10 platforms, most of which we think of when thinking of platforms: social networks, search engines, marketplaces. And the idea is that those are the gateways for commerce and interaction online. But if they become important enough, they can become gatekeepers. And here the DMA works with very, not to say simple, but at least clear thresholds. So we don't look at market power, which can be a nebulous concept, but rather turnover, which should be clear from financial reports and such. The number users. This is generally not public, but there's a reporting obligation on platforms. And once they reach 45 million users, they're presumed to be an important gateway. And of course, we want these positions to be stable, so these thresholds have to be met over the last 3 years. And working with these clear thresholds should lead to a more quick designation process, limited to 6 months rather than a market power assessment, which can take more than a year. Looking ahead a bit, the companies that I expect to be designated gatekeepers are, of course, these GAFAM firms. There's 2 or 3 other firms that might qualify. I think TikTok being the most obvious one, but this instrument was clearly designed for these GAFAM firms and not too many others. Of course, to put the regulatory burden on them, but keep other platforms free to compete and not burden them with compliance costs. Then the final part of this is the obligations. So there's a lot. I think there's a division is between the negative one, saying you can't do this or that, and this is close to competition law, the classic injunctions. This is anti-competitive, so stop doing that, a cease and desist order. I won't go over each of them here. They're discussed in more depth in the paper I've linked to, but more interesting perhaps because it's less competition law related are the positive obligations. And the idea here is more to give competitors not only a chance to compete on the merits, but even potentially help those competitors. For example, by giving them access to data. So Google search, Google will have to share data, clickstream data of its search engine. I talked about learning effects earlier. The idea being that startup search engines can rely on that search data to train their own algorithms. And if it is the case that the competitive position of Google is determined not so much by their quality, but rather just their size, well, then an obligation like that should make it more easy to compete with Google. So that was the bird's eye view. Now, shortly, could it make sense to export this or at least adapt it to other markets? Well, perhaps a lot has been made about this Brussels effect, and this could become an example of it. I think the most important thing to realize is, of course, that there's different ways for this to be exported. Of course, competition enforcement already, as we've seen, there have been some cases with global compliance. I think the Bundeskartellamt, so the German competition authority in Amazon Marketplace is an interesting example where Amazon said, okay, these terms and conditions that we have to adapt here, we'll adapt them globally. Same happened with the Japanese Fair Trade Commission that's changed some billing policies of Apple's App Store. This is de facto. This is coming from the firms themselves. If we would, export competition enforcement or even the Digital Markets Act, that would be rather the jure, the legal exports. There are interesting examples of at least other competition authorities potentially being inspired by decisions by the Commission. I think the Competition Commission of India and Google Android could be an example of that. But, while this can happen, I think an important limit that's not always duly recognized in the literature is that there's true limits to this transferability, depending on the regime we're talking about. Because firstly, when considering competition law, the goals of other jurisdictions might be different. I think South Africa is known to have broader goals relating to workers, development, equal opportunity that are not present in EU competition law. So that could limit transferability. Perhaps even more importantly is that the platforms to be regulated, the conduct we want to regulate, and the remedies imposed to regulate can be different. Starting with the platforms, there are some platforms that are truly global. I think Google Android, for example, is the mobile operating system of choice globally, with a smaller market position for iOS. The same goes for Google Search. The same goes for some of Facebook's platforms and perhaps Uber. I think China tends to be the outlier where not all of these platforms are as accepted. Then there's some platforms that are leading mostly in, say, Europe or the US. For example, Apple has mostly a strong position there. There's specific platforms depending on the jurisdiction. Take a lot in South Africa, which our market inquiry goes into, Flipkart in India, which Manju mentioned, different mobile money systems like M-Pesa in Kenya. So, of course, you can't just export this or that provision. There is a benefit to having these provisions fairly largely defined. So it talks about an online intermediation platform and not a specific one. So that's potentially a good threshold everywhere. But of course, you want to adapt the way that is defined in terms of not only the definitions of platforms, but certainly thresholds to be reached. Then I'll move to the conduct. I mean, even if conduct is similar, of course, the effects that the conduct has depend on the market situation. I think, Take a lot is, reading it into the market inquiry, doing a lot of the things that Amazon is doing, for example, in the US and the EU. So that conduct is very similar, but the effects may still depend on the context that they happen in. I think it might also make sense for different regimes to focus on different practices that have the greatest potential benefits. I think for Global South, certainly certain jurisdictions, it might make sense to focus on access to these platforms, which is less of a focus, for example, in EU antitrust enforcement, and on fair competitive practices, which didn't used to be a focus, but now the DMA is embracing. And of course, remedies need to be tailored, and there's a lot to be learned here, mainly from the mistakes of EU competition law enforcement. And it's great to see that, of course, other jurisdictions already building on those lessons learned there. Taking an example here from the intermediation platforms market inquiry by the Competition Commission of South Africa. Throughout the whole inquiry, you can read sort of the realization that a lot of remedies imposed in these EU competition law investigations were ineffective. And of course, that's a good start to then, when getting to the remedy stage of this inquiry, to do it differently, certainly, and then hopefully more effectively. So I'll end on whether a DMA-style regulation, what it takes to implement that. Of course, the EU, before it adopted DMA, had been enforcing competition law in digital markets for 20 years since Microsoft, and for the last 10 years, quite intensively. In one of the previous slides, I've shown all the precedents for each of the obligations of the DMA. So this is a well-considered document, where there was enough expertise on these practices to say, okay, in our market setting, these are likely to be harmful. So it's good to do enough of that background work, and market inquiries here are very useful. So it's great to see, I think, that a lot of jurisdictions are carrying them out. South Africa, as we mentioned, but also, for example, in Kenya with their digital credit market inquiry, and now also one in the groceries and food delivery platform markets. I think in terms of scope, the gatekeeper concept, tends to be imported from EU legislation in the documents I've read, which can be a good idea, at least if tailored enough. I've spoke a bit about that before. Other, institutional limits might need to be kept in mind. Of course, the DMA enforcement hasn't started, but already a pretty serious team has been tasked with its enforcement. According to the latest reports I've read, it would at least 200 people would be working on this, divided over the competition, DG Comp and DG Connect. So technical experts, legal experts working together, economists, obviously. But even then, that 200-person team is thought to be insufficient. While the idea is, of course, to have a less resource-intensive enforcement system that works ex ante, I think the resources that it would still require are not to be underestimated. And a final thing I'll mention is that while the EU took a gradual approach by not first, of course, going through these cases, but also by having the platform to business regulation adopted in 2019, which is sometimes overlooked, but I think a lot of the The issues identified in the sector inquiry in South Africa relate to, for example, transparency of advertising, etc., which was regulated in a separate instrument. That's worth a look. So, well, these are some conclusions, but I don't want to go too much over time and leave some room for questions. So I'll stop there and see what you, Bella, or any of the attendees would like to hear more about. Thanks so much for listening.
Okay, thank you so much, Friso, for this presentation. I don't know if I'll take you back to your slide on the negative obligations.
Mm-hmm. Sure.
And as I had earlier communication with you, some of the participants in the audience may not understand some of these terms. And maybe you could just briefly explain what is an anti-steering clause, because I see this is one of the conduct that has been identified in the FCFTA competition protocol, and also the recommendation in India against anti-competitive business, and what it means for SMEs, the anti-steering clause.
Yeah, great question. And I think it also relates to another question from the chat on whether we should distinguish sort of between platforms. So I'll try and take that together. I mean, the DMA is a very specific instrument in the sense that it has a list of, I think in total about 20 obligations, but each of them is sort of targeted at a specific platform. So it looks like a general instrument, but really the obligations are targeted at least types of platforms. So the anti-steering obligation you refer to is very much targeted at app stores, which I've talked a bit about at the beginning. And well, the problems with app stores are manifold, but one is they're very high fees. So any developer has to pay a 30% fee on purchases in app and subscriptions, at least of digital content, not physical goods. And they have to pay this fee, even though if you go online to their website rather than their app, you can often get the same product at a lower price because they're not subject to the 30% fee. But Apple and Google have these specific provisions in place and contracts with developers that say you can't steer consumers to cheaper purchasing options. Of course, nobody really benefits except for these platforms because consumers pay higher prices. Developers will end up with less of the price based by consumers, and developers often are these SMEs, small undertakings, often local undertakings. So this is a very classic transfer from business users that can be local to these digital platforms that tend to be global. So that's why anti-steering is, I think, a very, very interesting provision. It's also a provision that can be implemented, or an obligation that's implemented quite easily because it's negative. In a sense, you just have to say, okay, delete this anti-steering provision from developer contracts. Of course, it's important that developers know about this, and so maybe you have to expressly communicate the deletion of a clause like that. But it doesn't require a sort of difficult remedy to design and implement. So that's a general thing with these negative obligations that sets them a bit apart from positive obligations, where a regulator really has to start thinking about how to implement them. Okay, Google has to give access to their data, but what does that mean? Can Google charge for the data? Which data exactly must be shared with other search engines? So in terms of design, those positive obligations are a lot more difficult. Does this sort of answer the question?
Yeah, it has. And I think it's also important for competition authorities to also work with data protection agencies, because some of the obligations also entail the gatekeepers not processing or combining data that they get from the business users for their own advantage. So Hardin and Manju, we've heard what Friso has discussed, the extent to which we can borrow from the EU or the US. So I would like to just understand if you really agree with some of his pointers, or to what extent should we draw from the EU experience?
Maybe I start. So thank you, Friso, for that. I think the EU has been leading on this. I think they took the steps quite early on, and it is from this experience that we have to learn, we have to engage, so that we, whenever we fashion our own interventions, at least we have regard to what has happened in the past. We have regard to what is currently happening in other jurisdictions. I have been, there was very early on, I think it was around about 2002, somewhere in South Korea, where Paul Crampton for the OECD had a session for regulators. So there was a big debate. Do we need competition or regulation? What would work? And summarized why we need an engagement like this, because I'll just quote so that says we do all of this so that we can learn from each other's successes and failures, so that we can stand on each other's shoulders and avoid reinventing the wheel over and over again. This to me is quite important, and what the EU has done is a very good reference point. Right, as South Africa, we continuously have, we are having constant dialogues with the EU to learn, and I would say this is a very useful benchmark. I know that people talk about transplants and how bad that can be. You must look at market context, but I think here we are dealing with the firms, with the global reach. And I think if we have to tweak things here and there, I think it's going to be very, limited tweaking rather than reinventing the wheel, as it were.
Okay, thank you so much for that, Manju. You're muted.
Sorry. Thanks for that. So I absolutely agree with Hardin 100%. I think the whole idea for why we look to borrow from other jurisdictions is because we found a solution that worked, perhaps in a different context, but still a solution that perhaps worked to some extent. And we're looking to ensure that we're not reinventing the wheel every time we're faced a problem as a global community, and we try to borrow from each other's best practices. But having said that, and because it is again EU that we're sort of looking to borrow from, my reservations in terms of, and again, in terms of where the two countries are headed and what ambitions they have for your digital economy will become something that in flavor or in spirit will be reflected in our competition or any digital markets regulations going forward. And I think over there, I do think EU's digital market priorities may be far different from what India is hoping to get out of from a digital competition law. And for that reason, while I'm all in for a legal transplant, I would just, try and ring the old bell again of, cautious optimism and say that we need to look out for local peculiarities, local contexts, and, and anything that ensures that competition law is not only simply brought in, but almost organically diffused and transferred into the rest of the ecosystem. And one place that where we might want to start again is perhaps how the rest of the country's state machinery sort of interacts with the competition regulator and its ecosystem, because I believe most of India's pain points come exactly at that stage, and that where the general courts sort of interact with the CCI, and that's largely because the general courts existed much before the CCI was instituted in 2002, and it's been a little bit abrupt of a transplant because of which CCI orders don't see the light of the day in terms of appeals very, very quickly, either before appellate tribunals or in the Supreme Court for that matter. So I'm just hoping that something similar doesn't happen, and our enforcement history with competition gives us good lessons for going forward. So yeah, just ensuring that our economic and political priorities are also accounted for when we talk about digital markets regulation, which are starkly different from where I believe EU is sort of heading. So yes, all for a legal transplant, but with a little bit of customized modifications, if you may allow me for it.
Oh, wow, that's amazing. And I picked the word, we need to look out for local peculiarities. And that's in tandem with what Fiso was saying, that some leading platforms are leading in Europe, they're leading in Global South. For instance, when we look at Apple, most of the people from Global South cannot afford an iPhone. So maybe Android might be the one leading because people are using Oppo or any type of phone. Professor Elena Fox, I've seen your questions, and would you like to ask it or should I read it out?
Sure. Thank you very much. Thank you, all of you speakers. That was really wonderful. I learned a lot from you. And one thing that you did not talk about was the pushback or the other side. In the United States, we see huge lobbying against any action to be taken. And what I said in my little comment was, even we just have no market power. But beyond that, we're really helping consumers. And so I often in the United States, we hear the comment all the time that everybody else is trying to get the very innovative American firms and just put shackles on them. So my comment was, my question was, could you comment on that? And what are you hearing? And what are your perceptions, both in terms of any legitimacy to the argument, but also quite separately about the huge lobbying campaign, if you experience it? Thanks.
Please, do you want to start?
Oh, yep, I can say something about what I've observed in Europe. I mean, I think there was a strong lobbying campaign, which you could see in indicators like, lobbying budgets and offices being beefed up. But interestingly, the DMA sort of held out as an example of the failure of lobbying or the ineffectiveness of it. Interestingly, this instrument, when it went to the different versions in the parliament and the council, became more strict rather than less strict over time, which is relatively unique. So what did happen, which goes to the other part of your question, is that, of course, is this good for consumers? Is it not too strict? Are there good arguments there? And I think from the start, this was already taken on board, and some obligation. There's not a general justification obligation in the DMA, but there are very specific justifications. For example, when dominant mobile ecosystems like Google Android and Apple iOS will have to allow other app stores to be accessed, which hopefully will come with lower fees, more choice, better conditions. Well, they can take legitimate steps to ensure the security and privacy of their ecosystem. So there's a little balancing act in certain of the obligations, but no general justification. I think that's the short rundown of what I've seen in the EU, but very interesting to hear from the others what's happening there.
Maybe I go. So thanks, Professor Fox. At least from our end, from South Africa, as I said, I think we waited a bit to take a step, and I think in anticipation of that, we thought we do what I think other authorities were doing. I think the UK, EU both first published some position papers or research papers just to situate the problem, so that there is some understanding. And I think since then, I think we do pick up that there is a lot of buy-in into this. We have not had strong opposition when we started the market inquiry. So if you look, our parliament has been, quite welcoming to all of this. So we have not had difficulties explaining this to lawmakers, what this is about. Of course, there could be the lobbying we do not see. But we try overcome this by making sure that whatever we do, whatever we say, at least it's informed by some, evidence. we are transparent in our processes. So we would not rule it out. It has not been as strong as we have observed in the US. So it has not been a big discussion point yet. But we do not take this for granted. So we constantly have to make sure that at least our perspective is well understood. I don't know if what would have happened if we had started with enforcement from the start. As the EU was picking enforcement, we had followed the same path. Maybe the outcomes would have been a bit different. But I think Professor Fox asked something about market power, whether the laws, do allow us, at least with South Africa, the Competition Act. Our reading is that the provision for market power is quite broad, but it's also quite permissive in a way. That the bar it's not that high for one to mount a case. I think the issue would be in most cases the effects of that kind of a conduct, sort of the local effects, which I think would be a challenge, but on a case by case basis. Thank you.
Yeah, I'll just quickly comment on this. So this was a question I was hoping to avoid a little bit, because I'm currently advising the government of India on instituting and sort of like coming up with a draft digital competition law. So I'm going to strictly speak about things that are outside my domain of confidential information. So yes, lobbying. It's very interesting to look at what's happening in India in terms of lobbying for two reasons. One, when you look at the depositions that were made to the Parliamentary Committee on anti-competitive practices with respect to big tech, you will actually see that there have been a lot of organizations that have sort of mushroomed, that are trying to become trade unions of sorts, that are trying to advocate for a fair and free digital economy. And you will actually see that local philanthropists are funding a lot of these initiatives. So I do believe that there is a shift or a change in the narrative in terms of we must allow the Indian digital ecosystem players to also flourish side by side big tech companies that has taken over a lot of the public narrative in India, and effects of this are coming out in different ways. That you will see that the majority of people that depose before a lot of these committees are all unions of small players. You will see that they have access to speak to the bureaucrats in power in terms of what is really going on. Several grievance redressal chambers where they openly come and voice their concerns. But it's not that this is something that started very recently. This has been happening for about 5 to 7 years. But I think there has been a significant push in this regard in terms of how seriously the legislators are trying to take these problems against big tech, and that's only picked off quite recently after global trends on ex-ante competition. The second reason why I say take all of this with maybe not a pinch of salt, but perhaps like a handful of salt, is because fistful of salt is because India is gearing up for its general elections next year. So that means there are going to be very, volatile trends that you will see in lobbying with a lot of actors and interested parties that are trying to get their own of their, bargaining share. So I would actually wait for what happens at the post-consultation stage once the government of India has floated a bill for public comments as to how that is received by big tech companies and all other stakeholders of the digital ecosystem. And that would perhaps be a good time to, gauge as to where lobbying really is going.
Oh, thank you so much. Time is not on our side. Maybe as we wrap up, Helena has mentioned something about lobbying, and I thought, would you like to talk about it in just 1 minute at the EU level?
Hello, thank you. I don't want to take too much space, but indeed, I think what is interesting, and I'm only following from distance, is that we see these organizations that are posing as kind of independent businesses and that are strongly sponsored by the big tech players. And I remember kind of very vaguely, because I was not around that much, but the Microsoft case was basically, you know, the kind of open source conversations were really a lot about tech companies that were sponsored by Microsoft to say that we like this standard, we don't like this standard. So I think we should be keeping an eye open for this similar trends here. And I think specifically on some aspects such as device interoperability, I've seen a bunch of like smaller associations, like developer associations, that pose as representing this kind of making strong this argument of chilling innovation, which is the usual one, you know, that we would chill innovation, that we would impose incredible costs on small companies, but that actually are speaking sort of on the script of big tech. I think I would assume, or there would be indications to say so. So I don't know if other authorities are, I mean, again, I'm speaking like looking at it from distance, but I don't know if other authorities have been noticing such kind of front associations.
Thank you so much for that. And just in 1 minute for the speaker, 1 minute, each one of us should tell us if you think we could have a world competition law for regulating digital markets, just like what we had anticipated under the WTO. In 1 minute. Hadid, you can start.
All right, thank you, Vela. Thanks for this, and again for the invitation. Just briefly, I think when we have looked at these issues of cooperation or international instruments, it seems to me the most feasible are usually at a regional level. So I would think that we should make use of our regional structures that are there. It could be in Africa, COMESA, SADC, ECOWAS, EAC, and now within the AFCFTA. There you see, you could potentially have some consensus, but also similar context. Because I think you have noted, I think when you talk context, it may not be the same. We may not be at the same level of development. So we may not be able to prioritize things the same way. So in that way, I think when we work on these issues at a regional level, but also try coordinate at an internet. So at a global level, we should do our best to coordinate our actions where possible. So this is maybe what I would say in a minute. Thank you.
Thank you, Manju, in 1 minute.
Hi, can you hear me?
Yeah.
Hi, can you hear me? Sorry, yeah. So world competition law, now that's a very interesting proposition. I do believe, again, because I deal with a lot of questions on interinstitutional coordination, which has been a huge problem for a country like India. I do believe that there is merit in some sort of a cooperation or some sort of a lowest minimum guidelines that, you know, perhaps we could all look into, particularly those within clusters that have similar socio-political considerations. But again, like I sort of started with, I don't think the economy is ever completely divorced from the politics of a country. And each of these jurisdictions come with your own socio-economic peculiarities. And in some way or form, competition law and policy ends up reflecting that, whether in enforcement, whether in legislation, or whether otherwise. So to imagine that there would be a world competition law, I'm not sure. I don't think I'm being able to get that far in terms of my imagination, but these are some obvious troubles that, you know, I would see. And more importantly, in India specifically, because we do not have a very clear-cut distinction between what is really competition law and what isn't competition law, because there's a lot of overlap between sectoral laws and competition law. As opposed to thinking about competition law as something that helps the market, or prevents the market from failing. I think an understanding that we all have now is that it helps the market sort of fail better. So the kind of emphasis that competition law and policy receives in India, at least, definitely is a step below say to the extent to which sectoral laws or sectoral regulators are given teeth to sort of react and actively take charge. And I would believe that would be a major reason as to why I would see competition policy and law not being sort of observed uniformly across all jurisdictions.
Thank you so much. Friso.
Yeah, I also find it hard to imagine a global competition law, and probably would not be the best idea. But there is an interesting question of what the ideal level is, especially when dealing with big platform companies. The national level can simply be too small. There's no credible threat going out from the national level because there could be the countervailing threat of market exit. So I think regional levels are definitely a good level to think of intervening at. And like Hardin said, it's difficult to define what the ideal region is. Of course, that also changes over time as countries develop. The European Union itself, has changed a lot over the past 50 years in terms of membership. So it shouldn't be a fixed level of cooperation. But yeah, those are some first thoughts there. Thank you for organizing this, Fela.
Oh, thank you so much. And now we've come to the end of this event, and at least we've understood both the Global South and the Global North approaches to digital markets regulations. And we've seen that the Global South are doing tremendous activities and coming up with measures that reflect their own peculiarities. So this is the first event we'll be organizing under Afronomics Law and CPLAN, where we'll be talking about different topics that pertain to competition law enforcement in a bid to increase awareness of competition law and also for the institutions. So feel free to send any questions, any topics you'd like us to discuss in future. And also if you'd like to appear as a speaker, also let us know. Thank you so much.
Thank you, Vela. Thank you so much.
Thank you very much.
Thank you so much, Adi.
Thanks a lot to the other panelists. I learned a lot from you.
See you soon, Fisa.
All right.
See you, Hardin. Bye, Vela. See you.
Bye-bye, Majid.